My background is in artificial intelligence, and I work in the film and entertainment space, building solutions for that, technological solutions. I've worked in a variety of different problem domains in tech, in, like I said, film, gaming, uh, anything that you care to name. I've had, probably at some point in time, at least had some tangential relationship to. Most recently in music space. So each different problem is usually totally different from the previous one, but it's driven by basically the field of computer science. It's a constantly evolving field, and in it, you're always pushing the envelope. So it's very similar actually to what we're doing with the campaign, that it's unique and has not been done before, but was inevitably going to be done at some point in time. When the public health orders and the declaration of an emergency that preceded it first became known to the general public, I was concerned that it was not adequately substantiated by science, or if it had been, that science was not being shared with the general public. And I felt that with 5 million people in this province as stakeholders in these public health policies, it was important that we know the reasons why people are being locked in their homes. And it was a major concern for me, and it still is. I got involved in this in, I believe it was around November or December of 2020. I was lobbied by members of our community. I'm still not clear why me, but for whatever reason, I stayed on the sidelines for a number of months, and the problem obviously wasn't getting any better. And so what I decided to do was organize our efforts into a logical entity, a legal entity, nonprofit, which we incorporated. And we set up a charter, bylaws, and we crowdfunded the entire operation, including to date. And we initiated a class action on behalf of, well, close to 5 million people in this province. And that was filed on, I believe it was 26th of January, 2021. I have worked in class actions before, but the main reason why I know at least a little bit about law is in my field, in the software space, it's actually probably one of the most litigious spaces on the planet, maybe up there with energy. And at one point in time, it was railroads. Other times, it was newspapers, and then it was energy. And today, it's tech. And so, in order to keep yourself out of trouble, to avoid getting sued for infringing on a patent or privacy breaches when you're collecting large amounts of personal information, or to make a platform or something function, there's a lot of risks that you need to mitigate and avoid. And along the way, you learn a lot about law, whether you wanted to or not. I was skeptical of what the public health officer was saying. I suspected that there was a virus of some form out there, and I still maintain that. But I was skeptical of the magnitude of its impact. I'm also concerned about the lack of involvement of science in informing public policy in our province. In particular, in our suit, we assert that science is the study of reality, and it informs public policy making. And in the Crown's response to our suit, they actually deny that claim. It shouldn't be a controversial position, but remarkably it is. And I think that speaks volumes to where we are today and how we got here. It's that science obviously does not play a significant role in public policy formation. Well, this certainly isn't the first lockdown in history. There's been many lockdowns for a variety of different reasons, and inevitably they're political in nature. And did that necessarily inform how we dealt with this one? I don't know. But I can say that a class action of this nature, as far as I know, in Canada, this has never been done before. We've never had a crowd-funded, publicly driven class action. Normally, what happens is lawyers instigate class actions and then recruit a perfunctory plaintiff. But that's not the case here. And so in that sense, this is experimental. And like I said, the field that I come from, we're always pushing the envelope and we're always innovating. So as far as the law is concerned, this is what I would call an innovation in that respect. So we do get inquiries regularly, sometimes daily, at least weekly, from those who have contributed to a parallel campaign, various fundraising or marketing arms, if you will, of Mr. Rocco Galati. And while we never sought to engage him and we never donated to his campaign, we've had very little interaction with him. We have been receiving complaints for an extended period of time. And initially, we paid very little attention to them because it's not directly related to the business we have at hand. However, these kept on going on for quite some time, and the allegations vary, but the general substance of them was that a substantial amount of money was raised for a COVID-19 related litigation. And for whatever reason, little, if anything, ever transpired as a result of that. We're obviously not a public regulator. We're not the police. We're not in a position to really do anything about that. But in response to all those inquiries, we did put up an FAQ making it clear that we're not affiliated with Mr. Galati because there were concerns that we might have been a marketing for fundraising arm for him, but we have absolutely nothing to do with him.
Is that case dead?
Well, there were a number of different proceedings or action suits, whatever you want to call them, that were commenced by Mr. Galati. I'm only aware of one substantive hearing that ever took place for COVID-related litigation on behalf of one of Mr. Galati's marketing arms here in British Columbia. And that hearing, I believe, was to have the proceedings struck for having violated the rules of court. And I believe that application was successful.
And there's another case that we've heard about with Brian Peckford. Have you any comments about that?
I've been in touch with Mr. Peckford. We have communicated periodically. He's obviously much older and wiser than I am, and he's a very valuable source of information for me, him and others of his ilk. It was disappointing to see the federal travel mandate challenge get struck, but there was not much that they could do about that. There was certainly, I don't think there were any shortcomings in how that case was managed from the plaintiff's standpoint. The problem was that the restrictions were rescinded shortly before that proceeding could be adjudicated on its merits, and as a result, it was struck on mootness.
So does that mean it's dead as well?
Unfortunately, that means it's dead. Unless they appeal it, I have not heard any information that they intend to pursue that. And the deadline might have passed already, but I hope that they do. But it is a concern. Mootness is always a concern. It's essentially a cop-out because if the government rescinds a public health order, then and any legal challenges that flowed from that public health order are basically deflected. They're torpedoed simply by rescinding the order. And that does not prevent anyone, because there's no finding of wrongdoing, that doesn't prevent the government from reinstating the same or similar public health orders at a later date. Yes, so Reiner and I, we saw eye to eye early on. I think he had reached out to me, or someone from his team had reached out to me maybe 2 years ago or so. And we had a quick Zoom call and we compared notes on what we thought was happening in the world and why, and the best way to navigate a legal challenge, the correct architecture for it. And we saw eye to eye on many things. And what I found was the best way to deal with a challenge of this nature is that because there are so many different demographics in our society, so many different types of people that were affected in different ways. Some were upset that they couldn't go into restaurants. Other people weren't able to see their favorite films. Others couldn't dance. Others couldn't see a dying loved one. Others were confronted with injection mandates as a healthcare worker. That didn't happen initially, of course. There were so many different types of public policies that affected people, and private sector mandates as well, that it didn't make sense to challenge each one of these things on an individual basis. It didn't make business sense. And so rather than plucking the leaves off of the tree, it made sense to go down to the foundational premise, which was the declaration of an emergency that all of these public policy and private sector mandates were ultimately predicated on. So it made more sense if you wanted to get rid of that rotting tree to chop it down at the trunk rather than pluck off the leaves. And so he and I, we both saw eye to eye on that, challenged the declaration of an emergency. And if you are able to have your case adjudicated on the merits on the basis of the evidence, then that's not an ambitious task, in my view, because that was based ultimately on the PCR test, which we know now is discredited and did not work. But getting to that point where evidence can be adjudicated on its merits is actually very difficult. And so we've had a lot of people who are continuously sending us documents and tips and so on. But that's really not our main hurdle. Our main hurdle is what's called procedural in nature, and getting to the point where we can actually have those documents and that evidence assessed by the courts and whether our public policymakers were reasonable in the decisions that they made. So one of the problems that we've had in our hearings was that they're popular. That should be a good thing, but sometimes they're so popular that we can't actually physically accommodate everyone inside of the courtroom. And there's been a number of times where people have commuted great distances or put aside work or other responsibilities in order to try and attend our hearings in person, but they were unsuccessful and they get turned away at the door because there's no room in the gallery. And unfortunately, you're not allowed to stand on the side. You have to have a seat. It's just the rules in the court. Obviously, we want everybody to be able to participate and see what's going on. And so I deliberated on this. I studied a bit of the case law, and there's a concept called the open court principle here in Canada. And that's basically a constitutionally protected right for people to be able to observe the judicial process. And it's necessary in a Western liberal democracy to ensure that there's integrity in how that system works. But that idea was devised at a time, obviously, along many centuries ago. 1867, I believe, was our Constitution. So what open court meant then and what it means today is very different than in Victorian England. And so I thought that maybe it's time that we ask the court to reconsider that concept and broaden its definition in a 21st century context. And we brought an application to allow the filming of a very important hearing that's coming up in mid-December. And there's most likely going to be more people there than tried to attend Air India or the Picton case. The problem is, of course, they can't all physically fit in there. And so we asked the judge for an order that would allow us to film that hearing. It wouldn't be in real time, but it would be made available online for people to watch and study. And there was a great deal of pushback from the provincial crown, Dr. Henry's counsel, and they were unsuccessful in defending against that application. The order was granted, and we established case law again. So this is the first time, as far as I know, in BC that a hearing of this nature has ever been filmed where the parties have contested the right to do so. There's been other instances in the past, but that was where there was no controversy. The parties were all willing to have certain portions of the proceeding filmed. In our case, the government fought tooth and nail, as usual, to prevent us from doing so, but we're not successful. It's more important, of course, that people actually attend in person. But like I said, there are some very good reasons why people can't. And our judge, I don't believe any of those concerns were lost on him. He was sympathetic to simply common sense arguments that people who are out of town or over on the island simply can't be there. And the court needs to grow up. So our judge was under a lot of pressure in order to issue a ruling quickly because either way, whether he had granted the order or not, obviously we needed enough runway in order to make preparations for our hearings so that there could be a camera in there and the various technical logistics had to be sorted out in advance. So he had to make his ruling not 3 months after the application, but as quickly as possible. And we're very grateful for him doing that. We went for lunch break, and when we returned, he issued his reasons from the bench, oral reasons, with the written reasons to follow, which were actually released this afternoon. Justice Crerar is, like all judges, he's highly intelligent. He's also, as judges go, he's a younger judge, and he's more familiar with the internet and IP law and so on. And so he understood the types of concerns and what would be required in order to do something like this, and whether the Crown's concerns could be taken seriously or not, or whether it was anything reasonable that we could do to mitigate their concerns. Well, normally in court, when you bring a normal suit, each time you go to a hearing for an application, say you want to compel a witness to produce certain documents, or you want to adjourn a trial or something like that, you usually have a different judge each time. And that's just how it is. It's totally random. But in a class action, for whatever reason, there's what's called a practice direction, which is kind of like a set of customs for how things operate at the courthouse. They're judicially managed. So you have a judge that's assigned to the case, and they're there from beginning all the way to the end. And in our case, we were assigned Justice Crerar. It is important that people are there physically in the courtroom, but it's more important that people have access to the courts to see what is actually going on, whether they're watching it from at home, or they're listening in their car, or they're physically there in the gallery. And the reason for it is well, there's a number of reasons, but one of the best reasons was one that Justice Crerar, I think, was quite sympathetic to. So Crown Counsel had argued that it was not prudent to have the hearing filmed, because it would, in their words, inflame the public discourse. It could create public safety concerns. And even if people were allowed into the courtroom, they are just too unsophisticated to possibly understand what was going on. I'm paraphrasing here, but this is effectively the distillate of their arguments. And Justice Crerar reflected on it, and he was of the view that, well, if people are ignorant about the judicial process, then having people participate and see firsthand what's going on would possibly, it's not going to fix everything, but it may make people better informed about how the judiciary actually functions. It's important that when people are in the courtroom, that there's courtroom decorum is maintained. So sometimes you will hear things that will enrage you. Other times you will hear things that make you want to clap. But both cheering and jeering is not appropriate. So keep stoic-like, presidential, and when the hearing is over, during the breaks or lunchtime or after, you can go outside and say and do whatever you like. But while court is in session, be silent. So Reiner and I, we have discussed this a number of times, and we recently engaged him to assist us with Dr. Henry's discovery. And so notwithstanding succeeding in getting certified, the discovery process is fairly complex. I would imagine there's probably going to be hundreds of thousands, possibly millions of documents that we're going to need to go through. And having a subject matter expert who's already gone through, not necessarily things at the provincial level, but understands the larger geopolitical context of what's transpired over the last 2 years could be instrumental in reducing our workload. So the certification hearing is going to take place on December 12th to December 16th, 5-day hearing. And normally what happens in class actions is they're not actually a class action until they've been certified as such. So until that time, they're simply proposed brought under the Class Proceedings Act. It's a statute that is meant to guide claims of this nature before the court. So class actions are meant to solve 3 particular problems. So access to justice, judicial economy, and behavioral modification. So access to justice means that, for example, if you had bought a defective product, it might not be worth your time or your money to sue for a blender that fell apart. But on the other hand, if 1 million people bought this blender and it was defective, then it would make sense that they should be able to pursue the civil remedy through the courts. But rather than having 1 million people run to the courthouse, it would make more sense if it was aggregated together. So that's that's sort of a combination of the access to justice and judicial economy. And the third point is behavioral modification. So that's the third objective of class actions, is to modify behavior, to incentivize the party being sued, the defendant, to perhaps produce a better product next time and not cut corners. So those are the objectives, but in order to bring a class action, you bring it under this particular statute, the Class Proceedings Act in BC. And it's simply proposed as a class action, but it has to go through what's called a certification hearing. In the certification hearing, the purpose of it is not to adjudicate on who is right and who is wrong. That's something for the trial judge to determine. It's simply to determine whether or not the suit, as it is framed, if everything was true in it, is suitable as a class action. So it's technical, it's procedural, as the courts would call it, but it's very important in a class action, because without being certified, you cannot proceed to trial as a class action. So once it's certified, you're no longer CSASPP or nonprofit as the plaintiff suing Dr. Henry. You're potentially hundreds of thousands, if not millions, of plaintiffs. It's a preliminary hearing, but for the sake of class actions, those familiar with them, it's arguably more important than the trial. The certification hearing is basically the most important step in the entire proceeding. Well, there's going to be 3 applications that are going to be heard there. The first is obviously our application to have it certified as a class action. And we divided up our class members, our proposed or putative class members, into different categories of people who have been affected in different ways by the mandates. And the second application is the government obviously wants to get rid of the suit. So they're bringing an application to strike. And that's not unusual at certification hearings. It's difficult for them to bring such an application before that point. So when they do bring an application to strike, it's typically at the certification hearing. And then there's a third application which we're bringing, which is to amend our suit, to strengthen it, to increase the odds of prevailing and surviving certification. So those 3 applications will be heard concurrently over the span of those 5 days, and they'll all be filmed. So our goal, of course, is to get certified, also to amend our pleadings, and to successfully defend against the respondent's application to strike. If we succeed in certification, then the next step is discovery. So at that point in time, Dr. Henry's Praetorian Guard is no longer able to shield her from being required to answer questions and produce documents. In the United States, they refer to it as a deposition. In Canada and the British system, it's called an examination for discovery. Different jurisdictions have different names for it. But the process is similar. A witness is summoned, they're asked a series of questions, it's recorded in the form of a transcript. In the States, in some jurisdictions, they even film it. Normally that's not done here. And so that's normally done outside of court, perhaps at a law firm or another venue. But it's also not unusual for the witnesses to be put on the stand at trial and be asked questions. So that's where evidence is generated at trial. So you can't, in applications along the way, courts make decisions based on evidence that's tendered through affidavits on paper. At trial, you can't do that. Evidence has to be given directly by a human being that's on the stand. You can show them documents, but there has to be a real human being on the stand. What will happen is beyond our control at this point in time. We've done everything we can to mitigate all possible risks. The other side doesn't know what's going to happen. We don't know what's going to happen. We may well lose. I cannot guarantee anything. All I can guarantee is that we will fight like hell, and that's what we've been doing to date.